their own internal audit plan. Sorry about that. I've been told to back up. And so we're going to start back at the top here. Thank you for joining the Road to HIPAA Compliance webinar. We are looking forward to discussing today's topic, which is trends in enforcement activity. There's a lot of lessons to be learned from the various enforcement actions that have taken place. And so we're going to walk through a few of those scenarios and see what lessons can be gleaned from those. First of all, we want to give you a little bit of a background on Kirkpatrick Price. Kirkpatrick Price is a PCI qualified security assessor and licensed CPA firm. We provide assurance services to clients worldwide. The firm has over 11 years of experience in information assurance by performing assessments, audits, and tests that strengthen information security and compliance controls. Our services include regulatory compliance consulting, which involves helping organizations develop their policies and procedures, performing their risk analysis, and developing their own internal audit plan. We perform readiness audits, which helps organizations prepare to be audited, whether by a regulatory agency or other independent third party. We also provide information security guidance and audit services. We conduct PCI data security standard audits, SSAE 16, SOC 2, FISMA, HIPAA, and ISO 27001 and 27002. We would like to invite you to connect with us through a variety of channels. We've got a blog that people really enjoy getting regular updates from and learn about current trends and activities and various articles that we post there. You can also check out our library of recorded webinars. We do at least one webinar every month, and all of those are posted there at kirkpatrickprice.com/webinars. We invite you to connect with us on LinkedIn, follow us on Twitter. During today's webinar, we will be live tweeting, so you can check that out during the webinar today, and also like us on Facebook in order to see our posts and articles that are published there. Also, during today's webinar, we invite you to ask your questions in the WebEx window there. You can go to the chat window. You can also go to the Q&A. And if there is something that you want more information on or a question that you would like to pose to our presenter today, please do that, and we will address those questions at the end of today's webinar. The recording of this event will also be delivered to you at the conclusion of today's topic. I want to introduce Mark Hinely to you today. He's going to be our presenter, and Mark Hinely is a regulatory compliance specialist with Kirkpatrick Price and a member of the Florida Bar with 9 years of experience in healthcare law, regulatory affairs, and internal compliance in the public and private sectors. His specific experiences include serving in the General Counsel's Office for the State Healthcare Oversight Agency, regulatory affairs for Medicare, Medicaid, HMO, and complex healthcare litigation. He is also SANS certified in the law of data security and investigations. And in addition to being one of the Kirkpatrick Price regulatory specialists, he's also currently acting as a contractor on the OCR Phase 2 project. We want to provide a legal disclaimer for everyone here today. This presentation is provided by Kirkpatrick Price for educational and/or informational purposes only and does not constitute legal advice. No attorney-client relationship is established by viewing this presentation. Should you need legal advice, please consult with your own attorney. And with that, I'll turn everything over to Mark. And as I said, please pose any of your questions that you have there in the WebEx window, and I will be gathering those and bringing them back at the end to address any questions that you may have. Mark? Jenna, I'm not seeing Mark's telephone icon next to his panelist name, so he might be in the attendee list needs to be unmuted, maybe.
We do it so far we have feed speed, so we've got to figure out like what feed speed is. Okay. Outside.
Sorry, Mark, I'm working on getting you on here.
I think, unfortunately, he might be one of the generic call-in users, so. Okay, he just dropped off, so he'll dial back in with his code. While we wait on him, I can cover the introduction and get that part started while he's dialing in. But you know, the first thing about enforcement is, you know, who is it who's responsible for these enforcement activities? When it comes to being HIPAA compliant, it is the law. If you have personal health care information in your organization, if you're providing a service to covered entities, if you are a covered entity, you must be compliant with those laws. And so who is it that enforces it? And the arm of the Department of Health and Human Services that does the enforcing is the Office for Civil Rights, the OCR. And of course, right now we're in the middle of the phase 2 activity, which is part of their effort to set up what will be the permanent audit and enforcement process. And so that's happening right now at a federal level through the OCR. But then you've also got, at a state level, the OCR training the state attorney offices. I see that Mark is with us now. I'll finish up this one point, and I'll hand it back over to him. But the OCR has provided training to the state attorneys general because there is so much activity. There are so many data breaches and incidents that occur nationwide. There is a lot to do that the OCR can't possibly get to all of the incidents and also be involved in some of the proactive activity that they want to. And so at a state level, there has been a lot of activity happening from those state attorneys' offices. So those are the two organizations who have the responsibility and the authority to provide this enforcement. And out of those enforcement activities, you have types of sanctions that happen from that, and that's where I'll turn it over to Mark and let you pick up here, Mark.
Thank you, Joseph. I apologize for the technical difficulties. So there are four types essentially right now that sanctions that are being applied to entities that are alleged to have violated HIPAA. Those include civil monetary penalties, corrective action plans that are the most detailed and require the most response from the sanctioned entities, and then also external monitoring and internal monitoring. So before we move on to the most recent enforcement activities, I want to give an overview of some of the historic enforcement activities. On the next slide, there's a helpful graphic that the DWT law firm put together, so I want to give them credit for this, but I thought it was useful to see the different enforcement activities conducted by the OCR and then also those conducted by Attorney General's office. So there have been, and this was up until the middle of this year, so we do have some activity that we'll be talking about during this presentation that covers beyond what the graph shows. But there have been 34 settlements as of the time this graph was created with 2 civil monetary penalty actions, and the average was about a little over $1 million for those settlement amounts. And the total amounts resulted in a little over $40 million, and those settlement amounts are in part what is funding the phase 2 HIPAA audits. And you'll see that monitoring has been required in a little less than 25% of the enforcement activities, and most of the time that's an internal monitor, but a few of the times there have been external monitors. And you'll see one of the numbers that probably is most interesting it says that 23 out of the 36 enforcement actions came from breach reports. And so we continue to see, and historically and in the scenarios we'll talk about today, where enforcement actions arise out of self-reporting. And then you'll see, as Joseph mentioned, that there have been 11 activities by state attorneys general over the last 6 years, and we'll see if that number continues to grow as HIPAA enforcement continues to grow overall. And then you'll see that the corrective action plans, the CAPs, take approximately 2 years. That's the period of time for which they are effective. So this gives us a little bit of a sense of the nature of enforcement activity. You can see that there wasn't much activity. There still really isn't a whole lot of activity compared to other government entities that have enforcement abilities. But halfway through 2016, we were at 6 actions. And so we know that there have been several since that date. And so we're on pace for a record year of HIPAA enforcement by the OCR. And the year, that's already occurred and the year isn't even done yet. So we've got, another month where activity could be announced, and we just had one announced last week that we're going to talk about. So why don't we start with that? We're going to talk about 4 different enforcement actions, 4 of the most recent enforcement actions, one involving, that I just mentioned, the malware to workstation, publicly accessible PHI that was available via an internet search, and then a situation where there were multiple breaches self-reported by the covered entity that resulted in the largest fine in OCR history, and then finally a situation where you had, among other things, a generic username and password that led to kind of an information security debacle. So we'll talk about each of those different enforcement actions individually and some of the things that we can learn from them, similarities and differences, and then we'll wrap up with some trends and some question and answer. So the first case is the most recent, and it was announced just last week. Occurred a couple years ago, but the investigation was finalized and the resolution agreement was finalized just last week. And so this involves the story that you may have heard about or read about from UMass Health. There was, just to give you the factual scenario, UMass segregated parts of its organization based on what it believed were the divisions of the organization that were subject to HIPAA, core components, covered components, and those which were not subject to HIPAA. And it did not designate a particular speech and language center as a covered component. So it didn't create any policies and procedures for the center or include the center within the scope of other HIPAA policies and procedures. And then it also didn't implement certain technical controls on the center's network. And what happened was a workstation at that speech and language center got malware, and that malware was a Trojan malware that allowed for unauthorized access of a little over 1,600 patient records that included names and addresses and social security number, dates of birth, health insurance information, diagnoses, and procedure codes. And that breach actually occurred in 2013. And so as a result of the breach and the malware, the OCR had a couple of findings for UMass. The first was that it was an improper hybridization attempt, and they said that UMass incorrectly segregated the speech language center as a covered component. And then the second finding was that it didn't install firewalls to control the transmission of PHI. And then the third finding was that UMass had not conducted a risk analysis until late last year, I believe. And as a result, they were issued a $650,000 monetary penalty, and their corrective action plan included a requirement to engage in risk management, including a risk analysis, updating policies and procedures as needed, and then conducting training. And so a couple of the lessons that we can learn from this UMass scenario are, first, with respect to the risk analysis. Kirkpatrick Price, we already conducted a webinar earlier this year. I believe it was the very first webinar in the Road to HIPAA Compliance series on risk analysis, and you can consume that material if you'd like to. And we believe it's one of the most effective ways to engage in HIPAA compliance, because not only was it one of the top findings during the phase 1 HIPAA audits, but it continues to be an issue, as we'll see, not only in this UMass case, but in the other cases as well. And one of the things in particular that we can learn from this is to include, really technical components within the risk analysis. One of the things that can occur is, even if an entity conducts a risk analysis, that it can end up staying kind of high level and not including technical components like firewalls and network management and network monitoring tools, not including activities like penetration testing or other vulnerability assessments. And so in addition to just conducting a risk analysis, we can learn that it's important to include some of the technical components. And it's interesting to me that not only would it be a good lesson to learn to conduct a risk analysis, but UMass considered the speech language center as not subject to HIPAA, and so it was segregated and believed it was compliant. But including a firewall at a place like a speech language center seems like an appropriate control, even if HIPAA didn't apply. So to the extent that your organization is involved with hybridization, or there are reasons to if there are discussions about whether HIPAA applies to certain divisions or parts of an organization, there are basic controls, information security controls that are reasonable and industry standards, even outside of whether or not HIPAA applies, and things like a firewall would be one of those. So first, lesson is conduct a risk analysis. Second is, include basic security measures in all systems, regardless of whether HIPAA applies. And then third, be careful about segregating your environments. This may be the only case that I know of that involves a finding of improper hybridization. And, since this case is about a university health system, obviously if you're a part of a university or college health system, you should take special note of this and review any hybridization designations. But even if you're not a part of a university or college health system, there are other organizations that may want to take particular note of this UMass case. The ACA has potentially expanded coverage of HIPAA to entities that sponsor health plans or insurance programs that pay for care. So employers may now be fall under the definition of a health plan under HIPAA, and therefore may be subject to HIPAA for parts of the organization. And then even beyond that, if you're part of a healthcare entity that is considering a sale or a merger with a non-healthcare entity, a nonprofit, or an organization that provides services that wouldn't be directly covered by HIPAA, if that entity were separate, there may be consideration for what that means if your organization merges or purchases or consumes another entity that wasn't previously subject to HIPAA based on this UMass case. So,
and Mark, I think I'll jump in at the end of each case if you don't mind. Mark and I talked earlier about how to handle questions and all that. So I think I'm just going to jump in at the end of each one and ask you my questions. This will be very entertaining because Mark, I haven't practiced this and I haven't given him any of the questions beforehand. So he loves being put on the spot. But, the question I want to ask before we leave this first case here is the failure to conduct a risk analysis. One of the most common questions that we get asked is, what should our risk analysis include? Everybody always asks that, and it's this broad question of, tell me what we should do to make sure that we do a thorough and proper risk analysis and we cover all of our bases. Obviously, in this case, they've made the decision or failed to see, the need to include this element of their business into their risk analysis, and so they didn't look at it. But I guess the question I'll ask you, Mark, that would be helpful to the attendees today is, what have you seen organizations do, or maybe even bad examples of what people have done that might prohibit keeping the risk analysis fresh, because that's one of the things I struggle with when giving people recommendations about how to conduct their risk analysis and what to make sure that they include, because it seems like people want to have a checkbox and, you know, a checklist to cover, and they don't want to spend a lot of time rethinking or expanding or, you know, putting fresh eyes on their environments and on what risks might affect them. So do you have any ideas or recommendations about what would keep an organization's risk analysis fresh from year to year?
Sure. That's one of the things that phase one uncovered was not only were entities failing to conduct risk analysis, but they were failing to conduct effective and up-to-date and current risk analysis, because what the OCR discovered was that there was what was essentially a copy and paste year over year, where the organization took what they'd already done the previous year, the previous 2 years, and simply said, are we okay? Has anything changed? And didn't really start from scratch or do any actual analysis. They just took what they'd done, asked if there was a need to implement any new controls, or if everybody was okay with the existing controls, and accepting the risk as it was, and then moving forward. And so I think one of the things to not do is to simply take last year's risk analysis and basically propose it as good to go unless anybody has any objections. And one of the things that is good to do is to ask, is there anything new within our organization that receives, transmits, or stores PHI since our last risk analysis was completed? So this UMass didn't conduct a risk analysis until 2015, but let's say they'd done one in 2013. And if someone had said, well, we have PHI over at the Speech Language Center, and we didn't include that in our risk analysis last year, you know, what do we do? Well, you know, that may have reset that discussion about, you know, the hybridization. So not only would have resulted in a fresh and up-to-date and current risk analysis, but it might have changed leadership's mind about whether or not they were properly segregating those environments. So I guess the short answer, Joseph, is ask what else do we have that now could possibly contain PHI that we didn't have last year. That's one way to keep a risk assessment fresh.
Yeah, and it is human nature to just very quickly brush over that and think, okay, nothing has changed, let's move on. You know, when we deliver audits, and it goes year to year, you know, when we come back to do the next year's audit, we always ask, you know, has anything changed? And most of the time people say, no, nothing has changed. You know, we've maybe hired a couple of people or whatever. And I remember one of the humorous things that happened to me one time. We had that conversation, nothing has changed. And then we worked on the audit and eventually went on site to visit the client. And when we visited the client, there was a whole new addition to the building. And I said, oh, what's going on over here? You're expanding. And they said, yeah, we bought a business. We bought a new company, and we're offering all these new services, you know. And so I laughed, and I was like, oh, you told me nothing had changed. And they were like, oh, well, nothing had changed except for this, you know. And it was a pretty big change. So there's always a need for a reminder to take a fresh look at that risk analysis from year to year. So we'll move on to case number 2 now.
So this is an even more significant case than the UMass one. This involved St. Joseph's creating a situation through their network that allowed for publicly searchable PHI, even through Google. And the specifics were they were involved in their meaningful use review, and they purchased a server, and that server had a file sharing application on it that allowed access to PHI. And the result was that there were 31,000 records that included all the kinds of very sensitive data that were accessed in the UMass case, you know, dates of birth and names and diagnoses and treatments and dates of service, Social Security numbers, and all of the very important pieces of data. And so this one was another situation where the organization was charged with a failure to conduct an enterprise-wide risk analysis. But in this case, St. Joseph's was also found to have not properly conducted change management, and they were hit with a $2.14 million penalty. So, you know, a little bit larger than the sanctions in the UMass case. And so the similarity is they didn't conduct a thorough enterprise-wide risk analysis either. But the difference was, in this case, there wasn't an issue of excluding a certain part of the organization due to hybridization. This was all of St. Joe's, which included several organizations, were all subject to HIPAA and were all part of the meaningful use assessment. But what happens is when St. Joseph's purchased this network server, they didn't go through and evaluate the settings on that server and whether or not the settings needed to be changed to prevent public from being able to search PHI through Google. And so they failed to properly test or to conduct any kind of test the security concerns after they installed that server. And so one of the things that we find in addition to risk analysis and risk management is an issue of failing to assess the downstream implications of changes that are made. So, initially Joseph gave that example of, well, we just bought a new business and we're physically adding on, and that wasn't even seen as a change, but they didn't even think of it when they were talking to their auditor that this was a change that needed to be discussed. But the second part is even knowing if those changes occur, making sure that we do the kind of proper testing that evaluates if our risk has changed, if the scope of our risk analysis needs to change, if the controls that we had in place previously are sufficient to address the risk now that our hardware or our software or our human resources have changed. So in addition to kind of pounding on that dead horse of the conduct a risk analysis, now we've got to remember to make sure that our change management procedures evaluating environmental and operational changes are sufficient. Joseph, did you have any questions or thoughts about the St. Joseph's, your patron saint?
I will ask you a question. Absolutely. I've got a couple actually on this one. I think one thing that would be helpful for the audience today is, could you give us a definition of the difference between what you do in a risk analysis versus what you do in risk management? Because that, to me, is key of this issue, and I think a lot of people struggle with practically understanding the difference between the two.
Sure. So I'll give my perspective, and feel free to amend or disagree. But the risk analysis is the first part. The risk analysis is the process by which an organization evaluates threats and vulnerabilities to its confidential information, the likelihood that those threats and vulnerabilities would occur, the impact if those threats and vulnerabilities did occur, and anything that's in place, any kind of control that's in place to prevent those threats and vulnerabilities from occurring or to reduce the impact if they did. The risk management is to take the information that's discovered during the risk analysis and act on it, to identify that there is no physical security policy, or there's a physical security policy, but there's no security cameras, there's no biometric readers or badge readers or anything like that, and creating a decision that says these are the appropriate ways to reduce the risk to our physical facility, and here's how we're going to implement those. Here's the resources, here's the timelines, here's the responsible parties, and making sure all of the risks identified during the analysis phase are reduced as much as reasonably possible.
Yeah, I think that's helpful. I think that we see that a lot. People take a very broad approach with risk analysis. They sit in a room, they bring everybody together, and they have conversations about the risk. And they just, discuss the fact that, okay, yeah, it's a risk to us that an unauthorized person could access our systems, and get information on our patients or what have you. And then they say, okay, well, what are we going to do about that risk? And then they discuss it. They say, okay, we're going to have this tool that does the intrusion prevention. We're going to have this tool that does the logging of access attempts and failed attempts. We're going to have alerts take place when somebody, tries to log in, maybe to illustrate that there's a brute force attack taking place. And so that discussion happens in the risk analysis, but a lot of times what's missed is then going out and making sure that that's happening, which is a day-to-day matter. Risk management is a 24/7 exercise after the risk analysis. So that's what I see quite a bit of. So do you think is there any merit, Mark, in an organization who's doing this for the first time? Year one, the risk analysis is very broad, but what encouragement could you give to help people start to make it more and more specific from year to year and move away from being so broad?
That's a good question. So I think inviting a third party in to review a risk analysis, to ask those kind of questions, just to go back to that first example you gave, they were telling you nothing had changed, and you walked in and within 30 seconds you knew that something has changed because you saw the construction going on. And sometimes it just takes a third set of eyes so that you don't see the same thing over and over again, even though things have changed. And so that could be a third party. That could be internal staff. Bring in different subject matter experts to put their eyes on the risk analysis or engage in the risk analysis discussion to see if there more specific and technical components that are being missed, risks that are being missed, threats and vulnerabilities that are being missed, controls that are being missed, or controls that could be included that the individuals who participated in the first year's risk analysis just weren't aware of because they weren't the subject matter experts. So I think the short answer would be bringing either some different sets of eyes, either external or internal, and potentially even both.
And I would encourage anyone who's in leadership or who is the coordinator of your risk analysis process in your organization to take it that one step further. Make sure you get proof. That's what we do as auditors. We trust but verify. And so when someone, and this happens all the time, one of the most egregious examples happened to me earlier this year. I was with a client and we were talking about logging, and they said, oh, yes, we have this tool, and we do logging, and we store all of our logs, and we monitor all of the logs, and we look at them every day. I was like, okay, good. You do that every day? Yes, we do that every day. And so I said, all right, well, let's log in to the system and show me what you do, when you do that every day. And the guy started logging in, couldn't get in. This went on for 10 minutes. He could not get into the system. And I finally just said, so you don't do this every day, do you? And he just put his head down and said, no, I don't. And so, as someone in leadership or someone who's coordinating the risk analysis, and you identify a critical risk and you discuss the fact that you're going to put these things into place, take it to the next step and go and verify that the things are in place and working, because without that, proper risk management is not occurring from day to day. I'll move you on to number 3 here, Mark. Looks like you went out with all of the masses last Friday.
So I was trying to find the best pictorial demonstration of what seems like it happened at Advocate Health with multiple breaches, where they had stolen desktops and a stolen unencrypted laptop, and then unauthorized access at a business associate. And I was trying to find a picture of people just fleeing. Everybody you're welcome in, and everybody you're welcome to take as many electronic devices as you want. So this is if a picture is worth 1,000 words, this is maybe worth 500 because it's close, but not quite what happened at Advocate. But this is the largest. This case resulted in the largest fine in OCR history. So as I mentioned, there were, I believe, 4 stolen desktops. Individuals walked in at one of Advocate's affiliate companies AMG and walked out with 4 desktops, which is just, you know, something I'd like to imagine how that looked with people just walking out of the office with some desktops under their arms. And then there was a stolen laptop, which is not as unusual, but that laptop was encrypted, or multiple laptops were unencrypted. And then there was unauthorized access by a business associate, with which Advocate did not have a business associate agreement. And so because of the nature, and these were all self-reported breaches by Advocate, they all happened in a relatively a 3-month period of time, I believe. So 3 breaches within a 3-month period of time, and it resulted in a $5.5 million fine and internal monitoring required by the OCR. So, and in addition to the fine and internal monitoring, the OCR required several things during, as part of the cap. Again, to repeat ourselves, the risk analysis and risk management were not sufficient. OCR also required updates of policies and procedures, and we're going to talk specifically about those because there's something that's different about this case. Training and distribution of those policies and procedures, a third-party assessment, and then the development of an encryption report. And so there's a couple of lessons that we can learn from this case. We'll talk about those in a second, but similarities first to the other cases, again, no risk analysis or no compliant risk analysis. And then like the St. Joseph's case, a lack of process for evaluating environmental and operational changes. But the differences in the Advocate case are significant. The violations were extensive. In fact, the OCR said that some of the violations went back to the effective data security rule. So we were talking about things that have been non-compliant for years. A second aspect that made this case different was the involvement of the State Attorney General's office in Illinois. And then the thing that's probably the most interesting about this resolution agreement is how specific the OCR was in the corrective action plan with respect to the policy changes. And that took 2 different forms. One, the OCR specified the policies that needed to be updated. They specified the device and media control policy, the facility access control policy, and the business associate monitoring and engagement policy needed to be updated. And then even more, they went into detail about what items should be included in those specific policies. So for example, in the device and media control policy, the OCR said that Advocate needed to identify the criteria for the use of removable media and then identify the procedures for obtaining authorization for using personal devices that accessed EPHI. And then third, addressing security responsibilities like disposal and reuse of devices and media, and then compliance monitoring. So the OCR also did that with the facility access control policy requirements, and then was the most extensive with regard to the business associates policy. So if you're looking for guidance, or if you're on what to include in those policies, or if you've got those policies and you just want to make sure they include what the OCR thinks those policies should include, then a review of the Advocate corrective action plan is a good place to start. It'll give you some good details. One of the other lessons that we can learn from the Advocate case, which is pretty obvious, is that a business agreement is necessary. So the OCR said that because Advocate disclosed PHI to a business associate without an agreement in place, that was actually a breach in and of itself. And then the fact that it didn't have a business associate agreement meant that it didn't have the assurance that the business associate would protect the information, the PHI, that Advocate was sharing with it. So, so the lesson is a BA agreement is necessary, but it may not be enough. I think there are more steps that a covered entity should take in doing their due diligence with respect to their BAs. Certainly a BA agreement is the minimum requirement, but even more things like knowing who your BA's service providers are, or BAAs, knowing the kind of risk analysis and risk management processes that your BA has in place, what kind of third-party assessments that they had conducted, anything else, because having a BA agreement may have satisfied part of the requirement with respect to the OCR, but the BA in this case had an unauthorized access through one of its service providers. So the BA agreement wouldn't have stopped the breach. It simply would have satisfied a regulatory requirement. So one of the lessons from this situation is a BA agreement is necessary, but it may not be enough.
Yeah, I think there's a couple things in this one that would be good to talk about a little bit more. First is you referenced the specifics being given in the corrective action plan about which policies and procedures for them to put into place. You know, for so long, corrective actions have stated develop, you know, proper policies and procedures. It's been a very generic recommendation. But I saw another enforcement action earlier this year that was very specific about, you know, this organization will implement the following policies, and it was a list of, you know, 15 to 20 different policies by name. Are we to take that as a hint that these are policies and procedures that we should look at ensuring that we do have in place in our organization?
Yeah, this is the most direct and explicit way that the OCR, outside of an educational opportunity, can give us guidance that these are areas where they're really looking. So we can learn from other people's negative experiences to identify the policies and procedures where the OCR is really paying attention to.
You know, one thing I caution people about is I mentioned the checklist mentality earlier. You know, just because the OCR said, okay, well, this organization needs to implement these policies, that may not be necessarily true for you based on risk. You know, your environment may be different, your risks may be different, and so your need for various policies and procedures should be customized and directly applicable to who you are and what you're doing as an organization and what your controls are. The thing that I try to motivate people to do is just to be in a position where they can defend what they have done, you know, to be able to articulate these are our policies and procedures, and this is why we have these in place, so that if somebody ever pushes back, an auditor or a regulator, you know, and says, well, why don't you have this? You know, you should be able to logically and authoritatively explain, you know, why you don't have that policy, but you have this one here and you made that choice. You know, trying to get people out of the deer in the headlights type of look about, oh, just tell me what I need. Oh, I don't have that. Well, I guess I'll go run and make that now. But really understanding what you have and why you have it so that you can explain it to a third party goes a long way. The other question I had for you on this, Mark, that and did you have something you want to say about that?
Yeah, I was going to add with that last item on the PowerPoint about the development encryption report. That's a good example of something that may be useful as a discussion point, but may not be the same applicability to other organizations. So, you know, one recommendation I saw was to do that encryption report as part of the risk analysis. And really, in this case, you know, we're talking about an unencrypted laptop. And so the value in these, looking at these enforcement actions is not just to identify an activity that was required in a corrective action plan, but to look at the reasons behind it. So, you know, if you're looking at an encryption report and you're saying, well, you know, do we have laptops that store or transmit or receive EPHI? And if we don't, then our encryption report's going to look different. Or do we have not just laptops, but tablets and phones that store, transmit, or receive EPHI? And then if we do, you know, how much EPHI does that device receive, transmit, or store? Are the physical safeguards sufficient? Are there alternatives to encryption that are reasonable? So just asking those kinds of questions are some of the value that the highest value that we can get out of these enforcement actions. It may lead us to an encryption report, or it may lead us to another aspect of our risk analysis that's more appropriate for our organization.
Right. Certainly you're going to have unique documentation from place to place, depending on what you do. Those are good points. And I just want to remind everybody again, if you have questions for Mark, please send them in. We have him in the chair right now. He can't get away. He has to be here. This is not optional for him. So this is the time to ask him the questions. Don't let me be the only one having all the fun here. Put those into the chat window or the Q&A window, and we'll make sure and get those asked. Another thing before we leave this one, Mark, that I get asked from time to time, and I don't really know that I know the answer exactly, but what is it that determines the penalty amount? You know, you see the wide variation in the penalties that are assessed. What kind of factors go into those penalty amounts?
So that's a good question. A couple of different factors are the number of patients involved, the number of patient records involved, the awareness of the offending party of the potential risk or the actual noncompliance. The UMass case was, you'll notice the fine was less than $1 million, almost $500,000, and the OCR said that's because UMass had been operating in the negative. And so I guess the financial standing of covered entity or business associate might even be taken into consideration.
All right, thanks for that insight. Let's move on to number 4.
So our final case is University of Mississippi Medical Center, and I just, for purposes of brevity, just called this an information security debacle because they had multiple factors. They were going for a variety of violations. They had a stolen laptop. They had a generic username and password for an Active Directory with 10,000 patient records, and they had a shared department network drive that could be accessed through a generic account. So you couldn't tell which user was accessing information on that drive. And one story I read or summary I read of this case said that the UMMC knew about this risk for years and didn't do anything about it. And then when the breach did occur, they didn't actually notify the individual patients that were affected or impacted by this breach from the stolen laptop and then the generic username and passwords. They posted on their website and they alerted local media, but they didn't actually go to the individual patients and notify them. So in this case, UMMC had several sanctions. They had an internal monitor. They were required to conduct a risk analysis and provide it within a specific time frame to the OCR. And again, going back to that idea of specific organizational considerations, the OCR required, as a part of the CAP, they required UMMC to come up with a plan to assign unique user IDs and passwords, and then do security awareness training and policies and procedures. So in this case, I believe they mentioned the information security policy particularly needed to be reviewed and updated as needed. So, so similarities to some of the other cases, you got a laptop stolen and you have a failure to do a risk analysis, and a couple of the things that are different, the lessons, checking default settings on software and hardware is a basic information security task that's, again, another one of those things that's not just specific to HIPAA. And then the second is ensuring that your breach notification process requires notification to individual patients and coming up with a method and the content that meets the rule requirements. So those are some of the issues with respect to case number 4. And their penalty was $2.75 million in addition to the corrective action plan and the internal monitor.
Because this one was so focused on information security issues, I'll bring in one of the questions that came in from Patricia here. And she asked about what could be an alternative to encrypting phones or tablets that do have PHI on them. There's so many different information security standards that are out there. There are different controls, and you can select different controls based on the risk. That's the way the NIST 800-53 publication operates. You've got different manners of applying encryption or access controls or what have you, based on your risk ranking. So just specifically on this one, are there any alternatives to actually encrypting those mobile devices?
Well, with mobile devices, a little bit more difficult, but the other alternative, pretty much you've got encryption and de-identification. So there's another way that you can control the accessibility of the ePHI, is just to make sure that it's not identifiable. It's not, that there's algorithms and programs that do that de-identification. That's one of the primary alternatives to encryption is de-identification.
I would also add, I think it's a mistake to allow mobile devices to have PHI on them without encryption. I think you should look for any and every possibility to put that into place. One of the cases that we're not talking about today was where iPhones, did have PHI on them. They were not encrypted. And, with that particular product specifically, there is an ability to encrypt, and you should look to do that, because that was the finding in that particular case, was that the organization lost the phone and it did have PHI on it. And I know more and more people are using tablets and phones to access apps that may have that type of information. But thankfully, those products have really come along very nicely with offering encryption and things like that. And she asked as a follow-up, will thumbprint recognition be enough? And that's an access control, making sure that you have a username and a password or some type of biometric. That's a way of restricting access to it. But encryption would be an additional control beyond that. So just consider that. We've got several other questions here. I think I may keep these until the end, but we are at the end. So let's go ahead and have you cover the trend slide, Mark, and then we'll come back to these questions.
So really briefly, what we're seeing is increased enforcement activity by the OCR. As I mentioned, the number of agreements that have been, resolution agreements that have been signed this year is already record-breaking, and we're not done through the year yet. Situation-specific consequences, the different requirements for Mississippi Medical Center to do unique user IDs versus the access controls, physical security controls by advocate. And then some of the things that we see in common with these enforcement activities is the lack of proper risk analysis and risk management, the lack of policies and procedures being up to date and compliant with mostly with the security rule, and then insufficient training, particularly security awareness training. Those are some of the common issues that we see that resulted in these actions. And then the final takeaway would be, the old saying that an ounce of prevention is worth a pound of remediation. So some of these activities that seem difficult, like a risk analysis, go a long way in easing the avoidance of a $2.7 million fine or a $5.5 million fine.
All right, well, let's go through a few of these questions here, Mark. I'm going to go ahead and answer one myself, and then I'll have you answer the others because they're both about business associate agreements. But the first one that I'm going to answer is from Stephanie, and what is the difference between a gap analysis and a risk analysis? And I would explain it this way. Risk analysis is a requirement of the HIPAA security rule. You must conduct an annual risk analysis, and that is not a specified way of doing that. We've talked about some ideas with that even today, but you sit down and you evaluate your risks, and you have to think creatively. You have to perform discovery and look, okay, what do we do? Where do we do it? Where are our employees? Where are our systems? What third parties impact us? And you really have to think very broadly in terms of what kind of risks are affecting you. And so you have to bring in anything and everything. That's why you want to involve a lot of different people from different departments, different functions within your organization to help you with that, because you may not know about a risk that someone else in a different department is more aware of. And so it's really an exercise in, learning about and understanding what risks face you and what technologies you have in place and what risks those bring in. So you have to think very fluidly and explore, what those risks are. And there's not a prescribed way to do that. There are different standards out there that you can follow, but at the end of the day, those are really just guides to help prompt you to think about, okay, and now what? And now what? And, what's my next step in this? And what's the next step? And so you have to think very broadly when it comes to risk analysis. A gap analysis I would define as when you're looking at the audit protocol that's published by the Department of Health and Human Services. It's a specific listing of controls. Here's an access control requirement. Here is a policy requirement. Here is, physical security requirement. And so a gap analysis would be going through something like that, which is a standard, and saying, where are our gaps against this published standard? So looking for a gap is looking for what are we doing versus what this standard, or in this case, this audit protocol is asking us to do, and just looking for the delta there between those two, whereas the risk analysis is looking for risks, which may not be defined, which may be totally unique to you, but that's how I would describe the difference between gap analysis and risk analysis. So then, Mark, questions for you. Adam asks, how much liability is geared toward the covered entity versus the BA if the BA's subcontractor is at fault? So if we think about someone providing services to the covered entity and that someone outsources a function to yet another third party, does the covered entity have to be worried about that? Do they take on any liability?
They do need to be worried about it. The basic answer is, and going to that case that we talked about, is the BA agreement is the baseline assurance that the business associate will do everything in its power to, or is doing everything appropriate to control information, including the way it involves with its own service providers. So, but there is risk involved to the covered entity, even if it's the 2 steps down the stream. So that just goes back to what, baseline, have a business associate agreement, and then I don't know of any guidance that would establish kind of the factors to delineate the risk upwards or downwards, but the BA agreement is the basic protection for a covered entity to say, here's where the controls are in place, and may be appropriate to include in that BA agreement the liability upwards and downwards.
Yeah, that's all good. And I just looked at the clock here, Mark, so I think that we should wrap up for today. I would, there was another question about business associates as well, and we did a webinar a few months back on vendor compliance management, so you might want to check that one out because we talk about a lot of these issues there. So I encourage everyone to check that out. Thanks for joining us today. Really appreciate you attending and for your participation. We are going to publish our 2017 webinar series, so be sure to look for the email regarding that. We'd love to have you join us next year for a monthly series as well in terms of the road to HIPAA compliance. You will receive your recording within a few days, and thank you very much again.